Welcome to The Link this week, and we have a new thought to discuss with you concerning your money, your business. And today we are going to court, the commercial court. Should you go to the commercial court or not? If you go there, what are you going to do there? What cases can go there? We'll be back in a moment. Welcome back, and tonight my guest is Mr. Vincent Mugabo, who is the registrar for the commercial court. Welcome, Mr. Mugabo.
Thank you, Samuel.
Let's start with a key question. People hear the commercial court. The word commercial means about money. I don't know. But what kind of cases go to the commercial court?
Thank you for the concern. Commercial court was established in 1996 and was given a specific mandate. And the mandate revolves around these matters. One, banking, insurance, transport, taxation. Those are the matters that we expect somebody in a dispute to bring to the commercial court. The commercial court also has specific jurisdiction, especially in terms of funds. If you have a claim less than 50 million, then that does not qualify to come to the commercial court.
Okay.
Any claim above 50 million in those areas can be brought to the commercial court.
So if I am below 50 million, where do I go?
If you are below 50 million, the chief magistrates around Kampala handle all the cases up to 50 million.
Okay, that's very interesting.
Yes.
And so you said on those 4 areas. So I have a shop, a big shop in Chikubo, and my neighbor, we're not agreeing. I can't come to the commercial court.
No, it depends on the dispute that you have.
Yeah.
But if the disagreement is related to your relationship, a working relationship, that would not be a commercial dispute. Because it does not fall in the banking, it would not fall in insurance, it would not fall in carriage or transport. So that would not be entertained at the commercial court. But there are other courts which deal with conflicts which are from neighbors and from other related areas.
Okay, that's very interesting. Tonight we're talking about a possibility of avoiding court.
Yes.
Though commercial court handles this, arbitration.
Yes.
What's arbitration?
Arbitration is an alternative dispute resolution mechanism where you refer a dispute to either a person or persons who hears your matter and makes a decision for you.
Okay.
But that person or the persons that you refer the matter is not a court of competent jurisdiction. What happens is that when you are setting up an agreement, a contract with a party, you can say that in case of any disagreement, we shall appoint an arbitrator. So an arbitrator does not necessarily mean to be court. So what happens is that in case the dispute arises, then you refer this dispute to that person. The processes are different, the procedures are different, but there are many advantages with that kind of process because you save a lot of time, you save on the costs, and you get the decision at the earliest opportunity from the arbitrator.
So do we have to sit in court when there's this person we have given to arbitrate between us? Do we need lawyers? Well, how do those things work?
Depending on the nature of the disputes, you may not need the lawyers. For us, we tell the parties that you were part of the agreement making. You were part of, you know how the dispute arose. If you can explain that to the arbitrator and you can do the documentation that is required, then you may not need the services of an advocate.
Okay.
But where you may not be in a position to draft the documents to follow up your matter, then it is advisable for you to have an advocate.
Does the arbitrator have to be some kind of somebody with legal background, or it doesn't matter?
You do not need a legal background, but you need to understand the dynamics of the business. For instance, if it is an insurance matter, you need some background of insurance.
Okay.
If you are dealing with a banking dispute, you need to understand. An auditor or somebody who is very well versed with commercial issues would be very helpful. So you don't need any legal background.
Okay.
But of course, on a selfish note, if it is somebody with a legal background, they help you much.
Okay. I understand that. This thing called mediation.
Yes.
What's the difference between mediation and arbitration?
Now, In arbitration, the person you send the dispute to makes a decision for you.
Say that again.
In arbitration, the person you appoint or the persons you appoint will make a decision on the nature of the dispute.
Okay.
When it comes to mediation, you refer a matter to a neutral third party.
Okay.
Who facilitates a communication between the parties.
Not necessarily deciding for you.
He will never make a decision for you, but he brings the communication that has been lost between the two of you, so that you can communicate and see where is the problem, where is the dispute, how best can we get out of this problem. He will facilitate a communication between you, the parties,
Okay.
but he will not make a decision. So that is the difference between mediation and arbitration. The arbitrator will make a binding decision. You commit yourselves.
Like a judge almost.
Yes, like you will hear the evidence, you will cross-examine, you will produce everything, like a normal litigation process. And the arbitrator will give an award. We call it award. The decision is an award.
Okay.
When it comes to
Mediation.
the mediator makes sure that you communicate. The decision that comes from the parties,
You people.
not the mediator.
Okay. What if the arbitrator makes a decision but we are not happy? What do we do?
Now, our laws require that the person who is successful registers that the arbitrator does not have the capacity to execute his decision. So you must register that award that has been given with the commercial court.
Okay.
Now, when you register, you serve it to the other party and say, I want my award to be executed, so I have registered it with the commercial court. Now, if you have grounds to object, if you are not comfortable, and you have grounds to object to that decision, the award that was given by the arbitrator, then you will make an application on why that award should not be enforced.
To who do you apply?
In the court where they have registered the award. So before the award is allowed to go on, it must be registered first with the court.
The court, yes.
Now, if the court at that time you are notified, then if you have grounds to object to it, then you bring them to court. And the court will make a decision. The decision will be either to confirm the award or to set it aside. So that's what happens.
So is there a point when, is there an appeal also in this case? I'm asking like a layman, really.
Yes. The law does not allow an appeal in the arbitration process.
Okay.
But what happens is that if you object and you are successful, then they may set it aside.
Okay.
So of course the other person will also lose it at that stage. But where the process went on well, the analysis of the evidence was very proper by the arbitrator, the court will confirm that award, and when it confirms it, it becomes now a decision of the court. And the execution process is now a process of the court.
Okay. What's expected of us? We have a business dealing maybe with you, and we say, in case we disagree, we should have an arbitrator.
Yes.
What's expected of us? Let me say the dispute arises.
Yes.
What are our commitments?
The first point of call is that when you are putting up an agreement, you must indicate that in case of a dispute, we shall go to an arbitrator. So that is the first part at the signing of the agreement. So that is a clause that we call the arbitration clause.
Yes.
It is the one now that empowers you to take the decision. Now, when that decision, when an issue now arises, then the parties have an opportunity to appoint a neutral person they believe can help them.
Yeah.
But there are instances where they are not able to appoint. They disagree on who would be the arbitrator. We have institutions like the CADA, which is Center for Dispute Resolution, where you can make an application and they appoint for you an arbitrator.
They are qualified.
Yes, they have a list of qualified arbitrators. When that is done, then they will call you and you do your paperwork.
Okay.
You put in your papers, you put in your agreements, and where you think the person has gone wrong.
Okay.
The person will call you, will request you to bring your witnesses. You will be heard like in an ordinary matter in court. When that is done, then an award is given.
Okay.
A decision is given by the arbitrator.
Okay.
Yes.
Now, what do you find you are in a commercial court? How do you gauge the uptake of this kind of resolving issues in Uganda so far? How do you gauge the uptake of arbitration or mediation for that matter?
For mediation, I should start with mediation because that is my area. For mediation, it is the uptake is very high because one, the law makes it mandatory for every civil action to first go through mediation.
Okay.
So if you file any civil matter in any of our courts, from the magistrates court up to the high court especially, and we have even now gone to the court of appeal, you must go through mediation.
Okay.
When it comes to arbitration, many advocates have opted for that because it has several advantages for them. You save a lot of time. There could be some cost implications because you need to pay that arbitrator, but still the disadvantages outweigh the are less than the advantages. So there's quite a number of people. There have been concerns with whether CADA is helping them or not. And now the Law Society is trying to make reforms to have even an arbitration cluster to help more parties access arbitration services. Okay. So we are going to that level where we have an institution of government giving arbitration, but also the private society giving arbitration services. So that shows that there is an urge, there is a need for people to use that alternative mechanism.
Okay, those are very important insights. Your last word in 1 minute.
What we would encourage is that we would encourage parties to resolve their matters, most especially through alternative dispute resolution mechanisms like arbitration and mediations, because of the advantages they offer. And of course, we have limited capacity at court to handle. We have issues of human resource, we have issues of backlog where we have so many cases. So we are not able to resolve all these disputes in a timely manner. When we get sufficient personnel, maybe we would be able to resolve. But as of now, we encourage more people to use alternative mechanisms.
Okay. Thank you very much, Mr. Vincent Mugabo, for giving us your time to explain and break down these issues. Viewers, if you're doing business, time is of essence. So you don't want to go and waste time in court, pay money over years. You're locking away money when you could have resolved these issues through arbitration or mediation. So you heard from the registrar of the commercial court, Mr. Vincent Mugabo, and try it and see it for yourself. Thank you very much for joining us on The Link.